It is now 8:13, actually 8:14. Today will mark the third full day of deliberations in the murder retrial of Karen Read. A lot of activity yesterday as the jury sent a total of 4 questions to the judge, leading to speculation the jury might be close to a verdict. Boston 25 legal analyst Peter Elikann has been with us every step of the way through the Karen Read trial. He joined us this morning to talk more about where things stand. Peter, did you get the sense at all the jury might be close to a verdict based on the fact they asked those 4 questions yesterday?
I was like a yo-yo yesterday, though, because at first when they asked the first 3 questions, and I thought maybe they're just trying to nail it down, see it's okay. Maybe they're going to come back after lunch and announce the verdict. And then later in the day, though, when they mentioned about when they kind of asked the question, how about if we're not guilty on 2 and we're kind of deadlocked on 1, what do we do then? And all of a sudden I said, oh, are they deadlocked? Is this going to go on for days like the last time? And so that's why I'm saying it was like a roller coaster yesterday. I don't know what to make of it. They could come back at 9:30 this morning. Maybe they just wanted to sleep on it, or maybe they're going to be deadlocked for days. And it's just every time people have been asking we lawyers for the last several days, when are they coming back with the verdict? When are they coming back? And we're all, whenever we try to guess what a jury's going to do, whatever mystical art they do in that room, we're wrong so often that I've given up trying to guess.
Let's dig a little bit deeper into that last question, the one that was asked in the afternoon yesterday by the jury. They wanted to know if they found not guilty on 2 charges but can't agree on another charge, as you alluded to. Would it be considered a hung jury on all 3 charges or just 1? And the judge said she couldn't answer that because it's a theoretical question. Does that tell you anything, and is potentially still confusion over the jury slip, which turned out to be a big problem the first trial?
Yeah, clearly the fact that this is the second time in a row they seem to have the same problem as the previous jury because of the jury slip. Now, I will say Judge Cannoni is on solid ground here because this is a tried and true jury slip that they've used for years, and it's been vetted and et cetera. And yet, so she's doing everything. She's not doing anything wrong legally, and they don't have a big complaint with her. However, we got to do something about these jury slips. The whole point, these jurors are not lawyers, are not legal experts, and why should they be confused? Why shouldn't we have a jury slip that is crystal clear, that makes it easy, that takes them by the hand, step by step? So they'll understand it. So while there's no problem with Judge Cannoni's order, I think at some point somebody's got to bring this up to the Supreme Judicial Court or something and say, we got to revise the jury slips, because this is twice in a row the same problem.
Those earlier 3 questions that we had talked about briefly, Peter, any of those, tell you something? You said when you first, heard the first 3, you're like, oh, maybe we'll have something here. But, the timing of the OUI charge, whether or not video clips actually evidence, and how a guilty charge on the lesser charge would affect the overall charge. Did you glean anything from those questions? Does those hint to you that maybe they're close, or did that lead you to think, well, there is more confusion here than just the jury slip?
Right, yeah, and me trying to I keep saying these caveats that I hate to try to figure out what the jury's doing, because I could just as easily be wrong. But there was kind of a buzz. A lot of people were thinking, well, maybe they wanted as a compromise. They were talking about the drunk driving charge. Maybe they were just going to convict her on that one, which is a minor misdemeanor. I mean, I've never heard of anybody going to jail without a prior, criminal record, unless there's incredible extenuating circumstances. You don't even wind up with a conviction most of the time. A first offense drunk driving is usually, they'll say, well, continue it for a year, we'll suspend your license, take the alcohol education course, stay out of trouble, and we'll dismiss it. So that would be a victory if she was just convicted of the drunk driving charge. But anyway, that's kind of what I was thinking was a possibility, if they were really that hooked on the questioning the drunk driving charge. Maybe they were just down to that. And that's why some of us were thinking they must be really close to a verdict. And then, as I said, later in the afternoon, when they talked about what if we're deadlocked, at that point I said, oh, here we go again.
Right. And if that's the case, Peter, I mean, again, the Judge Cannoni would tell them, keep working and get back in there and keep working. We haven't reached that point yet, but that's a distinct possibility, is it not?
Yes, if there is any time the jury says they can't come to a decision, the judges can't say, well, okay, let's forget about the last 8 weeks or whatever, the months and months and the millions of dollars spent. So they want to do, any judge wants to do anything they can to avoid that. So they send them back again, and then they come out and they say, we're still deadlocked, we'll try some more. And finally, about the third time, they give them the kind of the explosive charge. Just, but at some point, if the jury really again and again, it goes on for days and they're just not, it's clear they're never going to reach a verdict. At some point, a judge has to throw in the towel and say, that was good for nothing. Yeah.
Yeah, that's what we saw last time. Well, I know you'll be on standby for us all morning should something happen, all day for that matter, and the jury will start deliberating again sometime within the hour. Peter Elikann, always appreciate your insight and expertise, Peter. Thanks so much.